a final call today on whether Section 377 of the Indian Penal Code or IPC, which criminalizes consensual sexual acts of lesbian, gay, bisexual and transgender, that is LGBT adults in private, amounts to denial of their rights to privacy and dignity, and that results in gross miscarriage of justice. A bench of three senior-most judges, Chief Justice of India T.S. Thakur and Justice Anil R. Dhave and J.S. Kheher, will hear a batch of 8 curative petitions filed by parents, civil society, scientific and LGBT rights organizations against a January 28, 2014 judgment by the Supreme Court dismissing their review petitions on the grounds that Section 377 is constitutional and applies to sexual acts irrespective of the age or consent of the parties. The review bench in January 2014 had agreed with its original appeal judgment on December 11, 2013, setting aside the historic and globally accepted verdict of the Delhi High Court. Vikas Sarthi, our correspondent who is following the story, joins us on phone line. Because the fact that Supreme Court took a call on re-looking at its earlier order makes this particular hearing today extremely crucial and significant, isn't it?
Right, Sakal. This is the last resort for the petitioners. There are some LGBT groups which approached the Supreme Court. Now Supreme Court has agreed to hear this curative petition in open court. So it seems that court is inclined to admit new facts, new line of arguments by the petitioners. If court feels that matter should be heard further, it will be listed. Opinion of Union of India and other states will be sought. Because at this point in time, it is curative petition. Once court thinks that we need an open court hearing in future, then all these things will happen, and Supreme Court will certainly ask Union to place its official stand on the issue. As far as this issue is concerned, Delhi High Court had decriminalized Section 377 of IPC. Later, some people challenged that High Court order in Supreme Court, and bench of Justice G.S. Singh said there is no legal infirmity with the Section 377. In fact, Justice Singhvi, when summed up his judgment, he said that we are not giving any opinion on the LGBT issue. We are just holding that 377 has no legal infirmity, and if Parliament feels that it
Having
should be
said
deleted,
that, Vikas, we have seen, besides all the media attention that this particular case got right from its inception, we've seen a lot of social activism associated with it, whether you talk about the NGOs or civil society or other stakeholders, either for or against this entire issue.
Exactly, Sakal. First of all, the LGBT community group said that we are not asking for a special right or even equal rights. What they say that just decriminalize, because they have been exploited over this issue. Sometimes the police and other groups harass them because of this Section 377. What they are asking is that they are not asking any kind of special right, special privilege. All they want is just to decriminalize, and there is a difference between legalization and decriminalization. They said we are not seeking legalization of LGBT rights. They are just seeking decriminalization of Section 377.
Right.
Now Supreme Court has agreed. What is the most crucial thing is the center stand, what center says today in the court.
All right, Supreme Court will take a call on that today. Thank you very much, Vikas Sarthi, for those inputs.